Excellent. Okay. Well, thank you everyone so much for joining us today. Very excited about today's webinar on renovations and risks. My name is Lindsay. I'm the co-founder and CEO of Super. We're an AI assistant for property management teams, so all about helping you with your property operations. And, from a software perspective, we really think a lot about collaborating and being proactive about planning to make it really seamless for property managers, owners, and residents. And we're really big believers in mitigating risk through good communication and strong audit trails. But when it comes to construction, there's always a lot of moving pieces. And for anyone that's been part of a construction project or embarked on a renovation before, it is a really big undertaking on a few fronts. It's expensive, it's time consuming, and I think something that people often overlook in the excitement to get a project started is how to mitigate the risk. Doing things like making sure you can even get the right insurance coverage, understanding the responsibility and liability if anything goes wrong, making sure you get all the right approvals from local municipalities, as well as from within the property if you're dealing with, like an association or a multiple tenant situation. And so I know I'm an optimist. I always hope that nothing will go wrong, but today we have two experts that can make sure that you take those extra steps to make sure that you avoid anything going wrong. So please welcome our two experts in both renovations and risks. We've got Christopher Tarnock, partner at DL Partners, and Isaac Schwadel, VP at Allsure Insurance Brokerage. So before I turn it over to them to kind of give us a little bit more information, if you haven't used a Zoom webinar before, there is a Q&A panel, so you can type your questions in as you go into that Q&A box on the bottom, and we'll make sure we leave plenty of time to answer your questions today. Excellent. Can we just kick off with really quick introductions? So maybe Chris, you can kick us off. Just tell us a little bit about yourself, and then Isaac, will turn it over to you.
All right. Well, first, thanks, Lindsay and the Super team for having me here. Happy to be here to shed some tips on this process through insurance and construction. Who am I? What do I do? I'm a partner at the real estate law firm of DL Partners. I've been here since 2010. What do I do? Is I help people with any real estate related matters, and the team here as well. I come in on litigation, I come in on construction matters, board representation. We handle acquisitions and properties, commercial and residential, pretty much a broad stroke, full service real estate law firm.
Okay, Isaac Schwadel, like Lindsay mentioned, Vice President at Allsure Insurance Brokerage. We are a boutique insurance firm based in New York City, focused on, I like to describe it as a triangle of placing policies for property owners and operators, real estate developers, and trade and general contractors. So super focused on real estate and construction, which is, the corner that we meet at today. Happy to jump in and share my experience. I've been involved for a little bit over 6 years, both in New York City and outside of New York City, construction projects and property. Honored to be on this panel with these esteemed panelists, and looking forward to jumping in.
Excellent. All right. Well, let's dive right in. I feel like this is kind of what everyone is here for, is you've just aligned on a project, you've got approval to kickstart some renovations or some major repairs, right? Very exciting moment to finally get there. But, I think what you've both identified already is that there are a lot of issues that can come up without proper planning. So I'd love to guide our conversation today in kind of the 3 parts of a construction project, right? The planning for it. So what needs to happen to make sure you're ready to go? What happens during the project? And then how do you wrap up a project and make sure that it's all, nice bow on it. You get to actually enjoy the fruits of your labor. So let's talk about that first part of it. And kind of, you've kind of alluded to this, the planning is really, really important. So what are the pieces of planning a construction project? And maybe let's start with, like, who do you need to have on your team to kick things off?
So I guess I'll jump in on that and just say, at the very beginning, I call it the honeymoon phase. Everyone is super excited to get going on a project. And for various reasons, whether it's a personal project, whether it's an investment, everyone wants to start construction and they want to get things moving. And that's great. And we're here as a tool to help facilitate that and make sure that the project goes smoothly. Obviously, recognizing what your risks are and trying to make sure those risks are mitigated. We're here today to talk about insurance and the do's and don'ts. Well, one of the things that you need to first focus on is insurance. So it depends on where you're building, or what actually it doesn't depend on where you're building. You're going to need insurance. You may need a little bit more detail if you're dealing with a building and a board, a managing agent, as opposed to, a property that doesn't have its own governing body. Getting the insurance documents right from the start is important. So getting this certificate of insurance, getting the policy, or at least the declaration page, over to your insurance agent, consultant, to get on board, have those reviewed so any issues can be addressed while you're moving forward with the other parts. That would be step number one. As a background, I've had many calls with Isaac about COIs and deck pages, and we've worked together on projects as well. So that's what I would do, at least initially, on an insurance end. I'll kick it to Isaac on what he does when he receives those documents.
Right. So if I can back up just a drop, Lindsay mentioned, you got approval in New York City and in most municipalities. In order to get approval for a major renovation, you would have to submit some sort of insurance documents, depending on the size and scope of the project. But that being said, oftentimes the requirements of the municipality are extremely low. If you can picture it as, state required car insurance, which is, very at the very, very bottom, that you have something, but that's not often enough to cover any significant risk. And like Chris had mentioned, is very early on in the process, if we can suggest working with your insurance professional and your lawyer to review those documents. The industry standard, like Chris mentioned, is what's referred to as a COI, or certificate of insurance. It's usually written on an Accord form, is the company that provides the standard form. A lot can be told from the certificate, but definitely not the full story. So what I like to tell my clients is that it's a good start, but it definitely doesn't show the full story. The full story is obviously in the policy. Just some examples, that myself and Chris have dealt with, and things that I've seen, on a fairly regular basis, is if there are specific exclusions that would not be listed on the certificate. For example, if you're working within an HOA or a condominium building, there can be exclusions for work on a condominium building. The reasons for that are beyond the scope of today's conversation, but just to be aware of the facts that a certificate of insurance, which is the industry standard, really does not show the full story. And part of the due diligence of seeking out the insurance is requesting a full policy and then passing it on to the whoever you're working with, a lawyer or insurance professional, to review that policy to make sure that the coverage is in place and makes sense. Another part of that, and also something to do in the beginning stages, is to have as much clarity as you can about the size and scope of the project. Unfortunately, construction, usually there's a lot, is a moving target. Things change as time goes on throughout, the life of the project. Sometimes it takes on a life of its own. But to try to identify as much as you can what the goal is, and then to make sure that the coverage aligns with that goal. Again, because of the details and and some of the exclusions that can exist in the policy, knowing what you're doing at the outset can avoid ire later on.
Mm-hmm.
So what I'm hearing from you all is get people on your team that are willing to read the fine print on these.
Yeah.
Speaking about fine print though, right, I think a really big part of it is when you're planning is finding the right contractors on your team, right? And then I'm sure, Chris, you deal with this a lot, the contracts for this work. What type of agreements do you want to make sure that you have in place?
Well, taking one step back, when you're going through the bidding process, a lot of times people get caught up with not letting the contractor know what the insurance requirements are. So if you are doing an alteration in your building, in your condo or co-op, it'll have insurance requirements that the contractor has to maintain. Otherwise, the work can't be performed. And sometimes, it's a lot. It's more than a contractor may maintain in its ordinary course of business. That would impact the bidding price. So getting that information out from the start to the contractor before the contractor submits a bid is going to be helpful, because if the contractor doesn't have that policy but needs to perform the work, that's going to be an added ask on the contract sum, right? And you don't want to be caught with that surprise when you're about to sign the contract and realize, okay, well, the policy's X amount more and you can't start the work, and everyone gets frustrated. What do you need with your contractor? The basic things are, you need to know what you're paying the contractor and what you're paying the contractor for. Okay. So it seems to be very, very straightforward, but outlining what the project consists of, including the drawings, including the specs, what is entailed. Build as much in as possible. Think of it as your playbook, right? The rules of the game for this project. I always say it's like a baseball game. If you don't have your set of rules, if there's an issue, you're not going to have something to turn back to, and then you're going to just create confusion. You're going to create a gray area, and that's not where you want to be during a construction project. It's going to help both parties. And then when it goes back to the honeymoon phase, sometimes it's that pause that's necessary just to clear, make it clear the obligations on both sides. Okay, it's insurance, but it's pretty much everything that goes on with the project. I see there's property managers, there's project managers here work in a building. So buildings have their own rules. It could be more stringent than the DOB rules. Every building has specific rules. They have to apply these rules to a project, because a board has to apply building rules equally across all units and all renovations, and they can't make exceptions. So they are going to be strict in enforcement. Make sure your architect and your contractor know about these rules ahead of time. Get a copy of the alteration agreement, have your contract review it. You don't want to have any surprises when the contractor did not realize it can't perform work after 3 or 4 o'clock, or there's restrictions on noisy work, or is there a restriction on the contract time where alteration work can be performed in its entirety. The building may limit the amount of working days, and that has to be known from the start. Otherwise, everyone's just going to waste time. Everyone's going to be frustrated. And the worst part about it is that people don't know about that, and then you start and then find out about it, then you're in a much more difficult situation. The contract docs are, you could pretty much use any contract docs. I've seen various types. I've seen manuscripts. I've seen AIAs. I've seen modified AIAs and different types of documents. It's the main purpose is just to outline the obligations of all the parties. Make sure you have the drawings, the plans, make sure you have the alteration agreement, make sure you have your insurance requirements, make sure you have your lien waivers. You can easily get into more detailed areas on what construction agreements require and why you require certain provisions and documents, but broad strokes, that's basically it.
And if I can add just a couple of points. Firstly, something that I've seen, again, beyond the purview of my profession, but just from being involved in this in the construction world. Oftentimes people like, oh, you think like, oh, I don't need a lawyer. Lawyers are expensive. They're all whatever, fill in the blank, whatever people's opinions are of attorneys. But in the long run, it only saves you because having somebody review someone experienced, who's been involved with this type of with this type of law, can save you a tremendous amount of heartache and money down the road. So my exposure is within the insurance requirements. An example that that we've dealt with is, like Chris said, the buildings have insurance requirements. If it's a larger project and it's an investor, there might be lenders involved who have certain insurance requirements. And depending on what route you go with insurance, but if you're using the contractor's policy and their policy will renew in the middle of the project, you need to have it. What you want to be clear in the contract is that coverage is maintained throughout the project, independent of sometimes a renewal can come in and it can be a lot more expensive, and the contractor's like, hey, I can't afford that, and then you get stuck in a bad situation again where the building won't let you do work or your lender won't let you do work because of that because you're not maintaining the proper insurance. So from a contractual standpoint, make sure that it's clear. And again, I'm not a lawyer, but if there is an added incurred cost based on renewal, that somehow should be worked out in advance. As much as you can work out in advance is always makes sense. So if the takeaway is involve first of all, A, is involve an attorney, and B, involve an attorney who's been there, done that, essentially. Chris is wearing a tie, but been there, done that, or got the t-shirt. Someone who's seriously experienced in in this type of work can save you a lot of a headache down the road.
Yeah, and I just, to that point, I'd say it's important, everyone can just say no and stop progress, but you need the individual. We're tools on the tool belt, as I like to say, and everyone wants to get the project moving forward, and we need to do that, but in a way also understand and mitigate the risks. So it's understanding the risks, but also how to address it, right, in a way that makes sense and in a way to move forward. For example, if you see a residential exclusion on a policy, working with your insurance professionals and having the insurance professionals connect independently to address the concerns to move forward. There's a little bit of creativity, there's a little bit of thinking outside the box, but at the end of the day, everyone wants the project to go forward, and we're here to advance that, not to step into the pathway of progress. And I mean, that's pretty much what we do.
Let's talk about neighbors then. I think especially in an urban environment, you might have a building neighbor, but you also might have block neighbors as well. What do you need to do to plan for those that are going to be nearby and impacted about that work? And I'm just coming at it from the assumption that neighbors will always be unhappy about any construction work that's happening, right? It's noisy, it's disruptive. So how do you mitigate some of that?
Well, that's I always say New York City is the city that doesn't sleep, but it's not yet complete. So there's always construction going on. We had construction right here next door to us, and I had to deal with the same noise that drives everyone nuts, and scaffolding and dust and all that stuff. But the most important thing is to really know what, when, why, how. What are you going to be asking your neighbor to do? I mean, everyone's going to require some outside work at some point. So knowing what your ask is, to have a grasp on that. It's the first impression, right? You can never make a second first impression. Goes to one of my tips: being organized, understanding what the DOB code requires you to do. What does it require you? And we're talking about access now, access to a neighboring property. Dear neighbor, we need access because DOB says we need to protect X, Y, and Z. Okay, well, how long are you going to protect X, Y, and Z for? What are you going to do to protect it? How long are you going to protect it for? How are you going to get the protection measures in and out? And what are you going to do with the interference of the use and enjoyment, right? Because that's when you get into the world of access agreements and access or license fees. But working, again, it all goes back to working with the professionals, having the engineers on board, understanding what the rules are and the requirements are, what the asks are of the neighbor, having your insurance company, and professionals on board to have the insurance documents ready, because you're going to need to name the neighbors as additional insured. The more you have on your side and together and organized, it's the better it's going to come off. It's going to your neighbor. Again, we can do a whole series of webinars on access agreements and the ins and outs and various provisions. And I could speak for hours on it, but that's sort of the high level answer on what you need to do with neighboring properties.
And if I can jump in there, so there's when you deal with neighbors, you can be the neighbor or you can have a neighbor. The first thing that I would suggest is that remember that is like Chris said, is that if your neighbor's doing construction today, you might be doing construction tomorrow, and vice versa. And the other thing I would point out is from an insurance standpoint at least, is to know how to toe the line in terms of not being careless of, just saying, oh, okay, fine. If a neighbor needs to do something, if they want access to your property, or if they're doing some significant exterior work or ground up construction, not to just, be completely okay with it. But the flip side is not to, be crazy about it. And what I mean is have extremely high limit requirements, or what, depending on the details of the project, is to keep in mind that being reasonable, like Chris said earlier, everybody wants, I mean, if you're a neighbor, and your neighbor needs to do work, they're gonna have that work done. So the longer you drag it out, is the longer the project and the heartache takes. If you're prepared, if a neighbor, again, and if it's an HOA or you're an investor, to have some sort of maybe protocol in place as a standard. If our neighbor wants to do work, this is our basic requirements. So you be prepared. You don't have to then start, scrambling. What do we need? What do we not need? Have some sort of standard, but consult a professional depending on the particulars, and then to keep in mind that the relationship is reciprocal. If you're reasonable, 90% of the time, I don't know the number, but there's a significant amount of time where the neighbor will be reasonable as well. Again, vice versa. So just to keep that in mind, and also to be from an insurance standpoint, to speak with an insurance professional to just to determine what is a reasonable request depending on the market. There's so many different variables depending on the risk, depending on the market availability, and depending on the size and scope of the project. What is a reasonable ask if you're the neighbor, if you're the neighbor, not the one doing the work. And the flip side is, if you are the one doing the work, to have what's asked of you reviewed by a professional again to see if that's within reason or not. And there's a lot more, like Chris said, that has to do with an access agreement. I'm sure Chris can speak to that, but from an insurance standpoint, that would be what I would add.
Yeah, it's true. What you need, what you're going to ask is what's going to be asked of you. So I always say, just be careful of what you've asked, because later that same requirement will be asked of you. And sometimes people have reciprocal agreements where they agree, on a future scope of work that's similar to what they're agreeing to in the present agreement. And some people are more neighborly than others. It's important to know the legal implications of this and why you need a lawyer, because you're entering onto someone else's property, and it's not something that really should be done lightly. And this is unfortunately why people have to have lawyers, but fortunately that you have to pick the right ones, right? So everyone says, well, why do I need a lawyer? Well, because this is New York construction, and there's a lot of complications. Buildings are buttoned up against each other, and everyone's living in close proximity, where what you're doing is not just impacting what your building is doing or your life, it's impacting multiple people. and precautions need to be taken to make sure on an insurance level, there's an insurance policy that's in place that can be, that can be there in the event of a claim. If there's a property damage claim, sometimes things happen in construction. You need to have those assurances, and that's a process that has to just, it, speaking as a lawyer, it needs to be done before your access. You need to go also onto your neighbor's property and do what's called a pre-construction survey. Okay, that's part of your due diligence. Same like with, it's almost like an insurance policy. You're going onto your neighbor's property, you're inspecting its current condition, right? Because the last thing you want to do and to have on your plate is a claim that you damaged their building, but the building was already damaged, right? So you want to know a snapshot what that building's condition is prior to you doing the work. That's going to benefit both parties. That's going to benefit the neighbor to be able to demonstrate that their property wasn't damaged and it only became damaged during the course of construction. And it also protects the person doing the work from claims that didn't arise from the construction or the renovation work. There's a lot of moving parts in it, but the biggest part is if you're going onto someone else's property. And that's why you need the agreement, right? So you can't just trespass on someone's property. They need to give you written permission to do so. And it's something that has transformed from being a very simple ask to have become a little bit more complicated in the length of agreements and provisions. And, it's just how this evolved in the city of New York. And it's a necessary step that one needs to take because you need to protect yourself and everyone else involved. And that's,
I'll give a quick anecdote involving Chris actually advising on some of this, and then we'll move on to what happens during a project. But I will say that the flip side of that as well is, so I invest in properties, and we were looking at an investment property where the developers were negotiating an access agreement with the neighboring developers. And the neighboring developers were asking for a blanket access agreement. So Chris, to your point on the who, what, when, why, none of that was answered. And it was just, we will have access whenever we want for however long we want. And Chris was like, I wouldn't touch that with a 10-foot pole. And that property is still on the market many, many months later. So it also has the inverse effect, right? Where it can depreciate property value as well if you're not careful about how you've negotiated that as well. So let's talk about what happens during the project. So all of this is the planning, making sure you've got your bases covered, make sure you know what you're walking into. You're now saying, great, I've planned as much as I can. I really hope construction is going to go smoothly. A lot of the times that's not exactly what happens. So maybe let's start with like, what can go wrong? What should you expect that might actually go off the rails there? Isaac, maybe some things that you've seen from some of the claims that you've processed.
Sure. Yeah, so the every contractor and whether it's owners or developers nightmare is a claim during construction. And it's actually a good segue from the topic before, neighbors. One of the most common claims in highly urbanized, densely populated areas is damage to neighboring properties, and this can extend again in places like New York City or other urban areas. So the access agreement is only with your immediate neighbors, or on 3 sides or 4 sides, whatever it is, whoever you need access. But depending again on the size and scope of your project, damage can go beyond the immediate neighbors. Something that we're dealing with one of our clients. This is kind of a one-off, but just to give you an idea, a project in New York City was being done by somebody else. They had a crane. The crane actually was in the news a little while ago. The crane caught fire, fell over, and hit the building across the street. Did a tremendous, keeping the numbers they're still being determined, but in the millions of dollars worth of damage. So again, just to reiterate what we said before, make sure that the policies that are in place while you're doing construction give you the proper coverage that you need depending on the size and scope of your project. I don't mean to sound like a broken record, but it's something that's of utmost importance, because if construction is anything, it's unpredictable, and that's what insurance is for. Like Lindsay started in the beginning. I try to be an optimist, very cup half full type of person, and that is. Insurance, the way I like to say it is insurance keeps your cup full. God forbid if something were to happen, and you know, and you weren't properly insured, things can get, go downhill quite quickly. So throughout the course of the project, make sure, that the coverage is maintained. The other thing is, again, on a larger project, is make sure that safety is of utmost importance. Safety for the employees, safety for pedestrians, people walking on the street, safety of a property of others. Unfortunately, again, this is more common in more urban cities where there's a prevalence of slip and fall attorneys, I guess we'll call them. People get hurt or claim they get hurt at construction sites. They see it as as an opportunity, if you will. If you get cameras, there are a lot of there's a lot of technology, there's a lot of things that you can be proactive about to avoid people claiming that they got hurt, or even unfortunately people getting hurt. So safety should be a top priority, again, both for property, for others, and for the people on the job site. It's something to keep in mind, and should be a top of mind. People kind of do it, and then it becomes a road. They have these toolbox talks at the larger job sites, and it is not taken seriously. It's definitely something that should be taken seriously. And interestingly, it's only a little bit of awareness that literally changes people's attitude towards it. There are apps and a lot of different technology and just awareness, signage and things like that people put on sites that can really change the attitude of people. And you see the differences in the numbers. We've seen it on some very large projects that we're involved with. The more seriously they take safety, and again, nothing too crazy, but to keep it on top of mind, it really changes the claims profile of that project. So again, claims are never fun. Trying to avoid them is the key, and the second thing is that in the event of a claim, you want to make sure that you have the proper coverage, so if something were to happen, you're covered properly.
And Chris, what are some of the things that you've seen go wrong during a project?
There's no limit. There's no end to the types of claims and what can arise. I'd say it really goes back to the planning phase, right? And what can go wrong really just drives the importance of outlining what happens if things go wrong. One of the things that I always say is just, don't pretend to know that which you don't know, and don't substitute your knowledge for that of other professionals. So I'm not an engineer, and I'm not an insurance professional. It's important to recognize where you are in the role of these matters, and to rely upon others who are professionals in their fields and who can come on in to complement what you do. To help move things forward. So if there is an issue, you can fall back on that document that you've spent time on framing out to govern your project. Many issues, usually it's money, involves money, it involves a dispute over, the work performance of the work, what was included in the contract, what does it change or whatever or not. What impact an action or an inaction had on the performance of work. It could be issues with buildings and unit owners in buildings, and disruption allegations and noise and dust and all this other stuff that comes with construction. There's always a hiccup. And I always say it's important to know you have something to go back to that can point the parties in the right direction, so you don't have that hiccup become more of a problem. It's a whole big process. Everyone has to be involved in it. In an owner side, being open, having open lines of communication in the contractor as well. It's a relationship between the two parties during this project. I've had construction projects where there were issues with plumbing and a damaged pipe and, water into a unit below. I had a construction project that involved unearthing bones that turned out to be sheep bones. Many different types of issues that can go on and on. Again, we can have another webinar of the interesting stories of construction in New York, but the most important part is there's the do's and don'ts. Spend the time during the honeymoon phase to go through to make sure you have the insurance policy, you have that recourse in the event there's a claim that you can, go against, and so you're not left with an out-of-pocket situation, which would be the worst case situation.
So we've got a great question as well that I think brings us to the next segment, which is wrapping up the project. And this question is specifically about getting sued years after an incident has happened. So maybe we can come back to that. Let's talk a little bit about what should you do to successfully wrap up a project, and then we can talk about this specific scenario. So you finished the work, you finally got there, despite all of the twists and turns and delays that have probably happened. Now, what do you do? Chris, I feel like, like a first thing that you should always make sure.
Well, first thing you got to know is, what did you define as completed the work, right? What is that? How is that defined in your agreement? That's an important one. What does substantial completion mean for your project, right? Does it mean that you have all permits in place? Does it mean that you can reside there or use it for its intended purpose? Does it mean you have warranties and guarantees that only punch list items remain? All these, and this, again, it goes back to why you need to spend the time at the spot during the honeymoon phase to outline this, because it just carries through the project. You're not going to know, or you're not going to be able to enforce the agreement if you don't have an agreement, or if it's not clearly defined of what is substantial completion. When do I need to release the retainage? When do I need to request certain documents? When is final completion, right? Typically, substantial completion is the property has reached a point in time where it can be used or enjoyed for its intended purposes, that you have building sign-offs and approvals. The governmental agencies have AOK'd everything, and that only punch list items remain. And you go through the project with your architect, and their punch list items are smaller items, maybe touch up paint items, missing handles, things of that nature that are on the smaller end. That's not going to impact the use and enjoyment or the overall function of the property. And then you have that period of time where punch list items are addressed, and then you come to your final completion. Final completion is another defined term in the agreement. Again, you're going to want to make sure all your close-up documents are in order, right? Permits, sign-offs, approvals. You don't want to have any issues with COs if you have a change in a certificate of occupancy. You're going to want to make sure you have an acknowledgement from your contractor that the contractor has been paid in full, right? That's called a lien waiver. That your contractor acknowledges the contract sum, how much the contractor has received, and that there's no balance, and that the contractor has paid or will pay, depending upon how the project is structured. It's a conditional and a non-conditional lien waiver, but that all subs and suppliers and vendors have been paid or will be paid. And you can require the same thing from subcontractors of the contractor. And that's your protection against a mechanic's lien being filed against the property. That's a closeout document. If you have a lender that's involved, you can have a lot more oversight from the lender, because it's their money. So they're going to have their forms, they're going to have their requirements. You're going to need to know what their requirements are well before you sign a contract. You don't want to have any issues at final completion with you telling a contractor, well, my lender requires this, and get that out from the start. Let the contractor know what the contractor needs to provide at the end of the day when the contract and the project is complete. the lender will, I'm not sure if I said it, but the lender's going to have its own forms, its own form lien waivers and releases. You're going to need to make sure you have those documents. You're going to need to make sure you satisfy the building requirements. If you're doing work in a condo or co-op, what does that condo or co-op require of your project, right? Is it going to require the building's architect to come on in to review things? What are those rules? Those rules have to be built in to your agreement with the contractor. And again, knowing these and outlining these and having these memorialized in the contract before you start, it's sort of like, it pays dividends. Why do this? I always say, I get asked is, I don't want to spend time and money, but I always say there's an extra 2 zeros at the end. If something goes wrong or you don't have it, you have to bring a lawyer in toward the end for a dispute. It's, you're going to spend more. And that's just how it is, because the parties at that point are probably going to be positioned. There's going to be a dispute, and it's going to take time to get through that dispute to reach a resolution. If you take the time, invest the time, and I'm not saying delay projects, but you have to know what you need to focus on. You have to know what risks come up, and you need to spend that time beforehand, and it's for the benefit of everyone. And again, that goes to wrapping things up. It's sort of what you do at the beginning will help you out at the end.
So if I
Isaac,
can just
it's from
add,
you.
I'm sorry. Yeah. So I would break it down just sort of in two ways, depending on the size of the project. On larger projects, something that Chris mentioned and has very far-reaching effects is make sure you get certificate of occupancy or a temporary certificate of occupancy. That affects, insurance going forward. If it's a new build or if it's renovation, a lot of this is on the property coverage side. A lot of carriers will not provide either quotes or competitive quotes for a property that does not have a certificate of occupancy. In other words, during construction, again, depending on the size of the project, most projects, the property will be covered under a builder's risk, which is property coverage under construction. After construction is finished, and a builder's risk is a time policy for the length, the expected length of the policy, 12 months, 18 months, 24 months, depending on the project. But once that has expired, you're ready to quote unquote move in, you're going to need ordinary property coverage. Many carriers will want to see a copy of a certificate of occupancy. Not putting that in the original documents, the original construction documents, as a requirement from the contractor can, cost a lot of money and cause severe delays because you're not going to be able to get people, not going to be allowed to move in without the certificate of occupancy, not going to be able to get proper coverage. That's for more, let's say, either, new builds, ground up construction, things like that. On smaller renovations, what I've seen many times, which goes back to something that Chris mentioned in the beginning, a smaller renovation, you're often going to use a smaller contractor. They might not have the proper insurance in place. They might, depending on the size of your project, they might say, okay, it's worth investing for this particular project. I will get the proper insurance. Making sure you close out completely is important because many times they will, if you have to call them back, they will no longer carry the proper insurance. And then everything what we discussed earlier, getting into the building, or satisfying whoever's insurance requirements that need to be satisfied is going to be a whole nother hurdle. So making sure everything is finished, the first time around, and making sure you're getting the certificate of occupancy are both extremely important from an insurance standpoint as well.
Yeah, and I guess I'll add a little bit of a story. On just because things have been done before doesn't make it right. And a lot of times you get caught up in the custom and just the process. Okay, this is how we've done things in the past, and we never had an issue with it. So why change things now? And so I had an access agreement. This is a few years back, and a neighbor was doing some work, and they needed to underpin a garage, and it was a single car, maybe it was a double car garage, standalone. And we had the contractor's insurance policy reviewed, and there was an earth movement exclusion, right? So, we pulled the contract up and said, well, we got a big problem here because if the garage collapses, what do we do? Well, what do you mean? There's no insurance, right? So your policy says if there's anything that happens, because you're doing underpinning work and excavation, there's no insurance coverage. Well, I've never had that problem in the 20-something years that I've been doing this. This is completely ridiculous, and it goes on and on and on. At the end of the day, both lawyers realize that this is a big problem, and we can't have this work go forward without addressing it. And we wound up addressing it in a particular way, but you can't rely upon the ceremony of what you've done in the past. Things change every day in New York. It's a constant evolving landscape. There's local rules. There's all these, case law comes out. It's what happened yesterday. You got to stay in tune with the right professionals. I think it's just really important on how to mitigate these risks. And that's just one thing that just popped into mind on
We've got just
things
a
that can
few
go
minutes
wrong.
left. So I want to try to get to a couple more of these questions from folks. So one of them is about, I think, Isaac, what you were mentioning about safety. So someone asked, we've got really good safety rules, toolbox talks, more than any other construction company, but we still get sued, especially in New York, for people falling off a ladder 3+ years later. How do we avoid this as a GC? And then there's some follow-up questions around insurance to cover from there. But what are ways to avoid kind of these retroactive claims?
So the unfortunate answer is that there is no way to avoid it, as long as, and Chris can speak more to the statute of limitations, but as long as a claim is within the statute of limitations, they can, they can still sue you. The reason why sometimes these claims do take longer to to make their way to to the GC or whoever it is, the trade who's doing it, is because originally the person who's injured doesn't think that that they're that badly injured. They hurt their back, it's hurting for a couple of days, and then the pain can linger, and then they're like, oh, you need to have surgery. They do the surgery doesn't work, and things kind of develop, and then it gets to a certain point where where we're assuming, where they get to like, okay, I need to file a lawsuit. This is something major. That's going the route of somebody who was really hurt. Unfortunately, in New York and elsewhere, there are lawyers, doctors, people who view this as a insurance companies as kind of a bank account. And what will happen is somebody who was hurt a year and a half ago is talking to somebody, a buddy of his was just on the side, and it's like, oh, I got X amount of money. It's like, oh, I also got hurt a year and a half ago, and then they'll go to the lawyer and start the process later on, whether whether it's true or not. I don't want to cast any aspersions, but oftentimes that's those are the two factors. Either the injury develops over time, or they realize over time that it's a more permanent injury than they originally thought, or quite simply, they got hurt, they didn't make much of it, and then they're talking to somebody else who says, they landed some sort of, jackpot from a lawsuit, like, hey, why can't I do that? I'm still within, my legal rights. That's, there really is no way to avoid it, unfortunately, the way the legal system is set up now. How to avoid, avoid these things? The best way is to be proactive. If having good safety is extremely important, and good on you for having a good safety, really good safety, being safety conscious. The only way to mitigate what's going, these types of situations is to make sure that you have very good incident reporting, and involved in that is never having an employee on their own. I know it sounds a little bit, I don't know, foolish, or kind of but that's the answer. There are so many injuries that I've seen, injuries to employees specifically, especially in New York, where it's lunchtime and a guy, finishes lunch early and goes back to do whatever he was doing, and for whatever reason gets hurt then, and then no one's there to see it. All they do is they hear some guy screaming and they come up and they see he's on the floor. So having some sort of buddy system or some sort of app, way to track people where they are, and then if there is an incident where something's happened, there's always a witness. Somebody could describe exactly what happened, and that can, assuming that everybody's on the up and up, that can really avoid the types, either the types of injury or the extent of what's being reported, because you get some sort of honest honest witness or honest perspective of what happened. And then make sure that incident report that you take at the time is as detailed as possible. List the names, the phone numbers. This way, if you do get this lawsuit later on, you're able to go back to that incident report and see exactly who was there, what was going on, and be able to call those people back to kind of clarify. The last thing, and I'm not plugging any specific software or app, but there's a couple of different apps that are on the market that do a lot in terms of tracking, in terms of safety reminders, a lot of different aspects of safety that, again, the numbers are surprisingly good when you use them. So it's the type of thing that's people try to be penny smart, dollar stupid. I don't want to invest in an app because it's another cost, another line item on the budget, but the long-term use of the apps, from what I've seen, can pay off. Obviously, do your due diligence, based on what the particulars of the app, but having protocols in place or systems in place that that can prevent it is really is the only thing to do. And unfortunately, just to close, people get hurt on construction sites, so that's the reality of it, and that's why we carry insurance. The other aspect I would just add also is for pedestrians, which has also become somewhat of a endemic, is that people, again, truthfully or not, get hurt. The easiest thing for that is having cameras, on the perimeter of the site. It saves a lot of people a lot of money, where it's very clear that either somebody has fallen not on your property, or it was very clear that they didn't fall, and it helps get the claims dismissed. So that would be my answer.
Awesome. And Chris, I feel like this is a good question for you. Someone's asked about project controls such as progress payments and lien waivers that you mentioned. Should these be part of the bidding process? At what point should they be introduced?
I mean, you could. There's that's a proactive measure. Generally, a lien waiver is relatively standard in form, so it shouldn't come as a surprise for a contractor to have received that request. Sometimes you'll get, the pushback perhaps would be, how many lien waivers do I need for a progress payment? Are you going to accept mine? Do I need all the subs, and what subs do I need them from? But I always like to, let others know what your general asks are going to be. If you know what the asks are, you have the documents, send them. If you're working with an attorney and pre-bidding and have those, let the contractor know they're going to have to be reviewed anyway. They really won't impact. I don't think they're going to impact the bid and the cost. The insurance will, I think, have more of an impact on what the contractor is bidding if the insurance is above and beyond what the contractor normally maintains, or procures. So the going back just real quick on to Isaac's point on safety, for an owner's position is just, you need to know when accidents do occur on your property. So you need to make sure you have a contractual requirement for the contractor to tell you within a specific period of time, hey, this accident occurred, and all those details that Isaac mentioned that should be memorialized. Well, an owner needs to know that as well. Why? Is because insurance companies need to be put on notice if in the event that there is a claim. The sooner you have that information, the better off you are. The statute of limitations period for negligence, which would be, the cause of action would be it's 3-year statute of limitation, so 3 years from the date of injury.
Amazing. We have
yeah.
a couple more questions that I will, I'll send these to you, Isaac and Chris. And what I'll do for all of our participants here is we'll send you a summary of today along with the video recording. And I'll also send us an email and include Christopher and Isaac's information so you can reach out to them directly with any other questions that you have. And it seems like, Isaac, there might be someone that wants to ask you about some insurance requirements and how to get the best deals there as well. So we'll make sure that we get that all circulated. Thank you so much to everyone for taking the time to be with us today, and have a great rest of your day. All right.
Thank you.
Thank you, Chris. Thank you, Isaac.
Lindsay. Bye.
Bye.